Hello and welcome to Property Perspectives. Today I've got with me John Ireland, and John works with a company or is Legacy Wills. John and I work closely to deliver a total solution for our clients. We can deliver the tax planning, and then John can deliver the final legacy solution in the event of a death. So John, welcome to the recording. We see a majority of people who still don't have a will. What's the cost and the consequence of not having a will in place in the event of a death?
Oh, wow. Well, the cost and the consequence is very, very heavy. As you know, I do quite a few talks on this throughout the UK, and I will often tell people of a couple of incidences. One, I think a famous one is Rik Mayall. A lot of people will remember him from The Young Ones and various other comedic, things that he had on TV. Now, when Rik died, he was worth around about £1.2 million. But because he died without a will, what it meant was that his wife got the first £250,000 of the estate and half the rest. Now, it's important to emphasize there's no inheritance tax between husband and wife. But when he died, she got the first 250 and then 495, I think it was, the rest, and the children also got the other half. Everyone in the UK can have assets up to the value of £325,000, commonly known as the nil rate band. And if you own any assets above this, it's going to be taxed at 40%. So his kids inherited the other half, minus his 325, gave a taxable estate of £150,000. Inheritance tax on that at 40% meant that they paid £60,000 as an inheritance tax bill that didn't actually have to be paid. If he'd had a will, there wouldn't have been any inheritance tax when he died. It's only paid on the second death. So that's one example that I give. There's another example of a client who didn't actually become a client, but we'll call him Dave. Now, he was living with his partner, Joanne. They weren't married, they had no kids. And all of the properties were owned solely in Dave's name. All of the rental income was also paid to Dave as well. I think he had a portfolio of around about 8 HMOs, rather decent sized ones. Now, Dave was busy, too busy to stop, take a breath and say, right, okay, let's actually meet up and get this will done. Now, as I say, all of the income was going into his accounts. They weren't married, no kids. Now, unfortunately, driving home one evening down the M4, rather fast as usual, Dave had a heart attack. Joe managed to pull the car over to the shoulder when unfortunately he had another heart attack and died on the spot. Now, Dave's properties are all owned in his name. And so, as I said previously, you can own assets up to £325,000. The challenge was the mortgage companies were not playing ball and they wanted their money back because their contract was with a dead person. But notwithstanding that, properties valued at £800,000, that's his asset value. Take away his 325, gave a substantial estate, £475,000. Take away the and taxed 40% meant that there was an inheritance tax bill of around about £190,000, which is bonkers. I'd suggested to them many, many times over the 6 months I was talking to both of them that not only should they have a will, but they could have owned the property on a 50-50 basis as tenants in common. And I can go over that again if you want me to, in terms of the differences between tenants in common and joint tenancy. But basically, if they'd owned it as tenants in common, he would have owned £400,000 worth, she would have owned £400,000 worth. He dies, of course, there's still inheritance tax because he's a single man in the eyes of the law. And let me dispel another rumour. There is no such thing as common law husband or wife. You're either married or you're in in a, oh God, the brain's gone, a same-sex relationship.
Civil partnership.
Yeah, precisely. Yeah. And in which case the law would recognise that. But if you are a single person and you die without a will, your other half gets nothing. And that's exactly what happened with Jo. She got nothing. They've had parents who are alive, so they inherited. Now, if they'd owned the property, as I suggested, which is to be tenants in common, Jo would have owned £400,000 worth, Dave would have owned £400,000 worth. Take away the 325 from Dave's half means a taxable estate of £75,000. At 40%, that's a £30,000 inheritance tax bill and not £190,000. And of course, if they had been married, there wouldn't have been inheritance tax to pay on the first death anyway. So I try to sort of emphasize these are the important things really about having a will and maybe not having a will and how expensive it can be.
So it's not having it can be, in terms of inheritance tax, produce a very, very large bill.
Correct.
So our clients are very, very much in this property investor space. So, and if we are property investors and making a will, what are the main things that they need to consider?
I think the main thing you need to consider is to get some advice from an experienced estate planner. If you go to your average high street solicitor, not that I'm wanting to cast aspersions, but your average high street solicitor will only take your instructions. And what generally happens in my 30 odd years experience as an ex-financial advisor, but also as an estate planner, is that people will go to a solicitor and they'll say, what would you like in your will? And, for most people, it's a box ticking exercise. So it will be a case of, right, I'll leave everything to him, he'll leave everything to me, and then it will go to the kids. What they don't consider are the repercussions if somebody dies, because if they die with a bog standard will, she inherits. Let's just say he dies, she inherits the house, because like most people, they own their property as joint tenants. Now, if that happens and at some stage she goes into a new relationship, let's just suggest that that relationship then flounders. She's gone in with that whole asset, the whole house. Joint tenancy, by the way, is a bit like owning your dining room table. You own it together, or maybe your family car, you own it together. One of you dies, you take it into a new relationship. That asset is in danger from not only their divorce, if they're going into that new relationship, it's also in danger from someone's death because it will go to the new spouse. Yeah. If that weren't bad enough, what happens if you need long-term care? Well, again, you could be forced to sell that asset if you need long-term care to pay for your fees. So there's a whole load of things that you need to consider. And that's why you need to go to an experienced estate planner and not just your bog standard high street solicitor. Hopefully that's answered the question.
Yeah, so there's so many things that need to be considered and it is very, very much about what are the intentions? Who do you want this legacy to go to?
Correct.
Rather than just saying, well, I give everything to her, he gives everything, she gives everything to him, and then we give it to the children. Yeah, because there's so many repercussions that can come out from it.
Absolutely. And I guess, as you were saying, especially in this property space where people work really hard, I've been working with property developers for many years now, and loads of them work really, really hard to build up what they've got. It doesn't make sense to risk it all by one, not having a will, or two, having a badly drawn up will, because I guess the other repercussions here is the value of the estate will grow and grow because it's property, and property does basically always grow in value. So when both parents, in my silly example, both of them die and it goes to the kids, what happens if the kids' relationships themselves are going south? It's not unheard of for someone to turn around and say, oh, I'm really sorry about your mum and dad. By the way, I don't love you anymore and I want some of what they've left you. The other thing is here that again, if there may be some kind of inheritance tax without the right planning, for the first generation, But if they leave it as a direct gift to the kids, when the kids die, there's going to be another lot of inheritance tax. So without the right planning, which obviously is something that you do on a regular basis, those assets are all going to be gone within 2 or 3 generations in inheritance tax. So, you know.
And it is, I mean, that's something that we do work an awful lot with our clients on, you know, in getting that tax planning correct, in getting the assets in the right places. Yeah. But then it's very, very much down to, you know, putting as much as we can beyond the reach of inheritance tax. Yeah. But then what is inside the estate then needs to be, you know, with the work that we do with you, is making sure that legacy then passes in the best way possible, you know, to these future generations, not just to the next generation, but to the subsequent generations as well.
Exactly that. Yeah.
Now, one of the things, you know, one of the things that we become very, very aware of is that, you know, making a will deals with, I suppose, the ultimate position that we find ourselves in, that we deal with the death situation and how we pass the legacy on. But there's also that period before where maybe we're not in control of all of our decision-making facilities ourselves. So what other things do we need to think about, John, other than just the will? What else should property investors be putting in place?
Yeah, well, I have this conversation with people at least 2 or 3 times a day. And very few people have got a will in the UK. And if they've got one, as I say, most of the time it's not drawn up properly. But there's another thing that people need to think about, and that's actually giving permission for someone to act for you if you do lack the capacity to act for yourself. Now, powers of attorney are things that I talk to clients about every single day, because if you lack the capacity to act for yourself, either through an illness or an injury or something, you know, that's debilitating enough, then nobody has the legal authority to act for you. Not your husband, not your wife, not your kids, not your best friend. Nobody in UK law can help themselves to your bank account or make your medical decisions. Now, there was a change in legislation in 2007, which did away with the old enduring power of attorney. You only needed the one. And that was replaced with the 2 new ones, which are health and welfare, property and financial. Now, if you lack the capacity to act for yourself, the first thing now that your GP has to do is report that to the Court of Protection. Court of Protection swing into action and they inform social services. Social services, in turn, will look at the records of the Office of the Public Guardian, because they want to find out if you've given the legal authority by way of a lasting power of attorney to someone to make decisions for you for health and welfare and property and financial. Now, if you've not got registered powers of attorney, social services take over. Now, their default is to freeze all of your accounts. They don't know any better. And let's face facts here. You cannot expect social services to finish off your conversion, to see in new tenants, to collect rent that's overdue, or repair a boiler, or whatever it is in your property world that needs fixing, because 1, they haven't got the skill set, and 2, you know, if you don't give someone permission to do it, social services can't do it. They freeze your bank accounts. No money going in, no money going out. So that means if you've got mortgages to pay, they're not going to get paid. Your tenant's rent is going to be returned to them as well. So they're going to be fretful, thinking that you know, they may be about to get evicted.
Or they're going to be very happy.
Yeah, they could well be, but you know, there's no utility bills being paid. The mortgage isn't paid. There's no council tax being paid. It's an absolute nightmare. So, for the sake of what, 250 quid, get your lasting powers of attorney done. That's all we charge per power of attorney, and they're really, really, really important documents. I mean, I cite when I do my talks. the unfortunate incident with Kate Garraway, who's been on TV quite regularly. And sadly, I hear her husband, unfortunately, has taken a very bad turn for the worse. But if people don't know about her situation, just Google her. Her husband, when it got COVID before all the vaccinations were released, and he was in a very, very bad way. My understanding is, and if I can recall, that Kate looked at treatments in the States, but then found out that she didn't have access to their joint bank accounts. She didn't have access to the mortgage. She couldn't remortgage their property. She couldn't make medical decisions for Derek. And she didn't even have the ability or the right to look at his medical records. Absolute nightmare. I wouldn't wish I wouldn't wish that on my worst enemy. These are the things that are fundamental to us. And without lasting powers of attorney, without you giving the legal authority to someone to act for you, you're just telling social services, I've given up my responsibilities. You do it for me. It's mad.
Yeah.
Get it done.
So it should be something that it's, in a way, that's probably more important than making the will.
Very much so, yeah, very much so. Whilst you're alive, you can guarantee that someone can look after you.
Yeah, I mean, you could be incapacitated for a short period of time. So it's not about losing mental capacity. It's not about old age. It's something that can happen to you, in your midlife.
Yeah,
you have an operation. Like I was talking to you before about my mother when she had an operation, and she took 12 days to come out from the anaesthetic. And luckily we did have powers of attorney, but we didn't need them at that particular point. Yeah. But somebody could be incapacitated. They could be in hospital. They may be immobile. Yeah. So who's going to sign the paperwork? And if they've got the powers of attorney, then not only do they come into play in later life, they can also come into play in midlife.
That's right. Well, the banks will tell you that if you if you haven't given someone your legal authority to act for you, whilst two people are compos mentis, for want of a better expression, both of you have the ability to sign and withdraw money and would sign checks nowadays if there are any left, etc. But once one of you loses capacity and you haven't registered the lasting powers of attorney, that permission is revoked. No one has the authority to go into your bank accounts. Yeah. So that alone is scary enough. Okay.
And more, John, we're seeing that in the property sector, people working with JV partners. So we see, an SPV being set up, and that there's two or more unconnected people becoming shareholders and directors in that company. I mean, does that have implications?
Yeah, most definitely, because if you, just take a silly example, if God forbid, but one of you in that arrangement has, like I had, has heart surgery, or maybe they have a debilitating disease, then what's the default? What does the other director do? How do they finish things without that person's permission if they're dealing with the bank, or they're dealing with the builders or someone else? They may need to have a joint arrangement to do those things. And also, as I say, if two people within that sort of arrangement have access to funds, the banks will revoke that authority if something happens to one of them, because they haven't got powers of attorney for the other shareholding director to act. Now, worst case scenario, if one of them dies, then what happens? I'll tell you what happens, really. It's down to the Partnership Act 1890, and all that business will have to be wound up. All of the debt, all of the profits is then given out to the remaining shareholders,
that's in the case of a partnership.
Correct. Yeah. But then again, would one of those partners want to work with the previous partner's wife or husband? Will they get on? Do they have experience? Will they continue to do things, it's better to have a partnership or JV agreement written out so that the business doesn't have to be wound up and everyone's clear about their responsibilities, when the project's likely to finish, how much each of them's going to get for the expertise that they put in or the money that they've invested, etc. All of those things are fairly simple things to put down, but they are important.
Yeah, and we see this, with limited companies. So where, with the shares, that, and if people have got simple wills where, they're written on the basis of, what I have goes to her, what she has goes to me, and then it goes to the kids. So if something happens to me, she gets the shares.
Yeah.
Right. And if we're the shareholders in the company, do you want to work with my wife, John?
Yeah. Yeah. That's the challenge as well. And I guess the other thing that perhaps I can, give a little bit more information here. When I do my talks, I do talk about leaving shares to the wrong people. So say, for example, if you've got what we call a qualifying company and you want to leave your shares to your spouse, if you leave your shares to your spouse as a direct gift, there is no inheritance tax between husband and wife. And providing your spouse still owns those shares at the date of their death, if it's a qualifying company, there is no inheritance tax. Brilliant. There's a thing called business relief. But let's face facts, a lot of the time, the shares are going to be left to a spouse that may not be involved in that business. So what do? They sell those shares. They then get the money for those shares as a personal asset. When they pass on, then there's going to be unnecessary inheritance tax. The way around that is to consider using some trusts, which either you can help with or I can help with.
You do the trust, John.
Right.
That's the bit that you do, right?
Okay.
And I think that this is a conversation that we have as part of the tax planning. Is if you have a limited company, you've got a property company, then where do these shares go, and what are the implications of the shares themselves? Because again, a qualifying company for business for the tax relief has to be a trading company. But in the vast majority of cases, if you built a property portfolio and you're holding rental property, that is a non-qualifying company. And Correct. The whole of the value of that company will sit inside the estate for IHT purposes. And this is where the tax planning has to come into play. And that's the work that we do with the client. Yeah. So getting to the end of really all of this then, John. So does making a will provide the total solution, or are there still things that can go wrong?
Well, again, I've got to emphasise the fact that we do the deftly named death planning, and I would always advocate that clients consider trusts. I mean, I can only give people advice. If they want to do something with it, it's down to them. But yeah, I would say that if you've got an asset values there that you want to leave to someone else, why not safeguard them in case they go into a new relationship, they get divorced, they have long-term care fees, etc., etc. Trusts are probably the best way that I know to protect those assets. I've got my own trust set up. I've even got my own lasting powers of attorney set up, which are super, super important. Yeah. So yeah, I guess the other solutions: get a will, get powers of attorney, and do get yourself some trusts. Speak to someone's experience. It's got to be better than just your average high street solicitor.
Yeah, I think you're right. So often when we talk to a client and we ask, have you got wills in place? Yeah. When did you last do them? Oh, about 15 years ago. Are all the children mentioned in the will? Oh, no, the youngest's not on there.
No.
So, and there's all kinds of issues. And what are the terms of the will? Oh, it's just, the usual stuff, everything I have to her, everything she has, to me, and then everything goes to the children on second death. And there's no thought, there's no planning. There's no tax planning in there. There's no thought about what the IHT implications might be. No. And there's no thought then about what will happen as far as future generations will go? How can we protect, how can we build this legacy and protect this legacy and pass it down through the generations rather than just to the next generation?
Yeah, correct.
And I think there's a lot of work that needs to be done on that.
I think the other part of the solution here, speaking with my ex-financial advisor's hat on, is if you've got some life insurance, make sure it's in trust. Because if it's not in trust, if you were to die, the value of that life insurance is deemed to pay out into your personal estate and will increase the value so that you'll end up paying 40% inheritance tax on it. Not only that, if it's not in trust, whoever the beneficiaries are will have to wait until probate's granted. That's going to take quite a few months. It's going to take even longer if you don't have a will, because it's just an absolute nightmare. No one knows who's meant to get what, etc., etc. So, yeah, wills.
Wills. I mean, this planning is very, very important. I mean, the work that we do on the tax planning is the route to paying, less tax on income, less tax on disposals, and less tax on death.
Yeah.
But how that assets, how all those assets then will get passed on is very, very much the work that we do with you to make sure that the clients are fully protected.
Correct. Yeah.
Well, okay. Well, thanks, John. Thanks for your time. Thanks for your input. To the viewers, thanks for watching. I am going to put John's contact details into the comments below this post. So if you want to contact John, and I recommend that you do, if you've got any concerns over this what John would call death planning, Dr. Death, but speak to John, because he's the guy that knows how to put you in the right position. So thanks, everybody, and speak to you all again soon. Bye-bye.